case to come before the court is State of Ohio versus James Burge. Party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up. I'll keep track of the clock and I'll keep you apprised of passage of time. Again, we're being visually and audibly recorded to be posted online, so try to be behind the podium as best you can. We have ready to do, so we're ready to proceed.
Thank you, Your Honors. May it please the court or the counsel. My name is Michael Stepanek. I represent defendant, appellant, and cross appellee James Burge. I'd like to reserve 3 minutes for rebuttal if possible. The case against Attorney Burge, then Judge Burge, had to do with financial disclosure forms. I know from reading the briefs and probably from your own personal experience you're familiar with them. What occurred in this case was the judge's opinion, which I think was a legal opinion, as to the answers to these questions. And the state ultimately was approached by a different judge in the common pleas court who had gotten some rumblings of their re-election proposal against him, so went to the county prosecutor and said, I think that Attorney Burge is doing some illegal things. It was thoroughly investigated, nothing came of it. The Attorney General got involved, and they said, well, maybe there's something in these financial disclosure forms. And it was separate and apart from anything that was originally, he was originally accused of doing, which amounted to nothing. Now, what occurred was Attorney Burge was, or Judge Burge then, was brought to trial, and at trial, he was accused by the Attorney General of being on the take, of having unlawful interest in public contracts, of filtering court-appointed cases to tenants in his building and things of that nature. Soliciting improper compensation was also one of the charges. So the framework of the trial was that he was basically soliciting bribes in exchange for rent. Now, at the end of the case, or at the end of the state's case, the visiting judge decided that all those counts lacked even sufficiency of the evidence, and he tossed out all those cases. But then what was left were some of the things that were in the financial disclosure forms. And he was ultimately found guilty by a jury of 3 counts of tampering with records and 3 counts of falsification. Now, the issue came down to whether it was possible to be found guilty of that, and I submit that it was not. Attorney Burge, for 2 of the counts, was indicted for omitting Whiteacre North as a business that he or his wife operated. Now, Whiteacre North was basically an LLC which owned a piece of rental property. An individual came in and testified that I, on behalf of Attorney Burge, had prepared an assignment of all of Attorney Burge's interests in Whiteacre North upon him becoming judge to his wife, Susan. And then at some point in time, that business was sold to Attorney Shimani Smith and his wife. Now, the Attorney General...
When you say the business was sold to Shimani Smith and his wife, were the actual membership certificates to Whiteacre LLC transferred to those people?
Yes.
So they have no interest in Whiteacre LLC at all?
The Attorney Burge, no. And there was testimony to that fact by Attorney Bob Ellis. He came in and he said, here's the assignment. It was marked as an exhibit, transferring any and all interest that Attorney Burge had to his wife, and then subsequently, all that interest was transferred to Shimani Smith and his wife. So there was really nothing that he had. And so now here we are talking about...
He's not getting 10K for any...
No.
Nothing?
No. And there was testimony to that. Alan Januzzi, at some point in time, there was an issue as to whether or when the interest reverted, because at some point in time, ultimately, Shimani and his wife didn't end up pursuing or finalizing the contract. They were supposed to, they took over ownership, and it was going to revert unless and until they did a certain thing, which was take a mortgage out on the building and pay off the note. They never did that.
So when that didn't happen, did they actually give those ownership certificates back to the
No, I think that it was self-executed. In the assignment was basically undone.
So you told me they actually executed certificates and transfer certificates.
That was my understanding. There was nothing in the record one way or the other with the certificates that were never entered into evidence.
So nobody knows whether the actual interest in the LLC transferred or not.
There was testimony from the attorney that prepared the assignment, the transfer of the interest from Attorney Burge to the Smiths.
But there's no certificates that verify that I no longer have any interest in this LLC. I have one-third interest in law. Because I signed.
Certificates, no. There was an assignment, but the certificates, no. Those were never introduced into evidence. But again, in terms of counts 1 and 2, the question was whether Whiteacre North was a business that he or his wife operated. And it wasn't even ownership. It was whether they operated the business. And it wasn't even a business. It was a company that owned a building. And that was it. There was no operation of any kind of business that took place. And I think that
The leases that were executed with the residents of the building, were they executed with Whiteacre LLC?
rent was paid to Whiteacre LLC, and sometimes rent was paid to Shimani Smith directly. All of those were admitted into evidence, and it was, depending on the attorney, either wrote the check to Whiteacre North or to...
For the utilities that each individual renter had in their own personal names, or in the name of that Whiteacre LLC, they paid their proportionate share?
The rent was $500 a month, I believe, and there were no lease agreements made. It was just, in terms of the utilities, there was no separate utilities for any of the individual renters.
Covered all the utilities?
Correct. Correct. But it made no money. There was actually testimony from the Attorney General's office that the business probably wasn't even worth $1,000, which would be something that you would have to list if you had any assets. This is something else that Attorney Burge was indicted for, not listing this as a real estate asset. Well, it only has to be listed as an asset if the value is over $1,000, and it wasn't. But I think that the whole point of a lot of this is that, and this is on page 555 of the transcript, the visiting judge said, look, you can bring in 5 attorneys to say one thing, and you can bring in 5 attorneys to say another. What is the nature of a business? We don't know. Whether this assignment to Whiteacre North, or of Whiteacre North, getting rid of it and going to Shimani Smith, was this effective? Everybody says yes. So what then, because somebody had a different opinion as to the nature of that assignment, whether that was effective, can that possibly lead, can that legal opinion possibly lead to knowingly making a false statement? And I don't think that the evidence was presented. And further, when it comes to tampering with records, you're looking at whether there was a purpose to defraud in some of the...
Another question. So the guarantee agreement that Burge signed with Lorain National Bank,
Correct.
it's my understanding that it prohibited him from transferring his interest in the building or the business, the Whiteacre LLC. Because it's not my understanding the property was in the name, the deeds in the name of Whiteacre LLC.
Whiteacre North, correct.
So I guess I'm trying to figure out.
He himself was personally liable as a guarantor on that mortgage. Correct. Now, that was an issue too, was whether he listed an entity to which he owed money.
Well, my question is, if he was a guarantor on the property's in the name of Whiteacre LLC, if he were to execute his membership certificates and transfer them to some third party, wouldn't he have essentially then transferred his interest in, on which that guarantee?
In Whiteacre North?
Yeah.
Sure, but I think he would still be potentially a personally responsible as a guarantor.
But wouldn't he also have then violated the agreement with Lorain National Bank saying you're not allowed to transfer your interest?
If he was, it didn't alleviate his guarantor responsibilities. And I think there was
What I'm trying
testimony.
to think of is, what's your reporting requirement on the financial disclosure statement?
There would be nothing regarding that, because in terms of whether he owned Whiteacre North, that was one question that they said, well, we don't think that this assignment was effective. And there was testimony brought in, the assignment was, entered into evidence, it was effective. A separate question then, and I don't know if you're relating the two, is whether he owed Lorain National Bank over $1,000. He didn't because he, as a guarantor, would only owe the money in case of a default by Whiteacre North on the mortgage note, and there was never any evidence of a default.
Yeah, I guess there's a question or two about whether, say hypothetically, Whiteacre North did make a payment. Does Lorain National Bank have the ability to go straight to Burge and say, hey, they missed a payment, you owe us the payment? Or would they have to foreclose on Whiteacre North first and then go after him afterwards? Was there an immediate ability for Lorain National Bank to go after him if they missed the payment?
I believe that under the terms of that specific contract, they could go after both at the same time.
Would they have to make a foreclosure action and just list them as co-defendants?
Under the terms of that specific contract, I believe that they could have.
Okay, well, spread it out, but what I'm trying to figure out is if Lorain wanted to file foreclosure, could they go for him before they do that, or do they have to file foreclosure against everybody?
I guess the nature of this particular guarantor agreement was that he would be, upon default, liable to pay the note.
Okay.
How they would actually do that, I guess, would be up to Lorain National Bank. I don't think anything would have prevented them from going after a guarantor.
Okay.
And that would, I guess that was the issue in the case was, does he owe money to them now or upon, default? Now, the Attorney General brought in a witness, Attorney Nick from the Ohio Ethics Commission. He says, wait, if you look at the frequently asked questions portion on the Ohio Ethics Commission website, it says that if you co-sign for a student loan, then you're going to have to report that as you owing money to somebody.
But when you co-sign, both of your names are on the same document.
Correct. And a co-signer is, I'm basically borrowing this money at the same time. A guarantor is, I'm going to pay it back if the other entity defaults. So there was that dispute there, and so the evidence that the Attorney General was bringing in was, look, a co-signer, you owe money either way. I guess the point of all that is, and again, this brings me back to page 555, I'll bring you back there 1,000 times, is the judge. He says, look, not Judge Burge, Judge Crawford, the visiting judge in the case. He said, look, he goes, you can bring in 5 attorneys to say one thing and 5 attorneys to say another. This case was rife with expert witnesses on both sides saying, well, this is a guarantor agreement, this is, it's separate and apart from a co-signer. Well, what are they looking for in the financial disclosure forms? They're looking for this specific thing. Well, I think you then...
I'm sorry to interrupt again, but how much time did you want to retain?
3 minutes.
Okay. So we got half a minute left.
Okay. So, how is it that I'm knowingly making this false statement if I've got attorneys coming in saying that, hey, this is certainly a legally supportable, position that you're taking here? We're not talking about, how old are you? And he says, well, I'm only 50 because I want to run for re-election as opposed to 66, so we can't. That's something that's certainly objective. This is something that's very subjective. That's a legal opinion. These are not, the things that these financial disclosure forms are calling for are not calling for things that are based on objective fact. These are things that are based on subjective opinions that we have presented legally supportable evidence for. So I think that it was error for these cases to even be brought to the jury. And I'll reserve the next 2.5 minutes.
Good morning, Your Honors. Catherine Mullen on behalf of the state of Ohio, appellate cross appellant in this case. I'd like to start by addressing the defendant's first assignment of error, which is the sufficiency of the evidence. The defendant's counsel has said a couple times during this argument and during the previous argument in this case that the visiting judge had noted that each side could bring in 5 different attorneys and hear different things. Well, that goes right to the heart of the standard of review for sufficiency of evidence, because the standard of review for sufficiency is when you consider all of the evidence in the light most favorable to the prosecution. So if the prosecution brings in 5 witnesses that say that the defendant didn't do this, he didn't sign these forms, and that constitutes a failure under the financial disclosure forms, that's sufficient evidence, and that's enough to deny the defendant's first assignment of error. In addition, I would note that Judge Schaefer, you had asked a couple of questions. The defendant did sign as guarantor for the Lorain National Bank loan. Not only did he do that, but he also signed a confession of judgment in which he agreed to be right on the hook for the money without having anything, anything additional needed. And that is in the record at transcript pages 597 to 98. We also had testimony from Thomas Brokamp, who was one of our agents, that the assignment to the defendant's wife, the 2011 assignment, was not recorded. We also had evidence from Chris Athey from the Lorain National Bank that the 2007 assignment to Attorney Smith, the bank was never notified of that. So the bank considered Judge Burge and Whiteacre North on the hook for that amount of money. So I think factually even the defendant's argument fails on that basis because there was evidence in the record to show that the defendant owed these debts, that the defendant had this interest in Whiteacre, and that they had this property interest. If you look at the financial disclosure forms, which I fill out, I know this court fills out, they're pretty straightforward, and when there's questions on them, the Ohio Ethics Commission has opinions out there that people can research, and the judge, being an intelligent and well-known attorney, I'm sure is aware of that. But there was a 2006 Ohio Ethics opinion, which I did cite in our appellee brief, which says that the filer is required to disclose interest in real property owned by an LLC. And that opinion is at 2006 Westlaw 6108654. There was also testimony from Rich Dove from the Ohio Supreme Court that the form says that members of LLC that own or lease real property must disclose that information. That testimony can be found at page 153 of the transcript. And again, also I believe there's some discussion of that at pages 151 to 152 of the transcript. And I think also if we look at the defendant's actions in that case, this case, that further supports sufficiency. In 2014, Attorney Burge went back and tried to file amended financial disclosure forms to correct the omissions that he had made in the previous filings. And I think that shows even on Judge Burge's part that he understood that he was supposed to have disclosed that information previously. The timing, of course, is a little questionable because at the time Attorney Burge sent those amended filings in 2014, this investigation had already been underway for 9 months. And all of these facts were made known to the jury when they found the defendant guilty. I'd like to turn...
That cuts both ways, though, doesn't it? I
I'm sorry?
mean, the investigation has started, he either amends it or he doesn't,
Well,
I think it would be more telling if he filed it without knowing the investigation started, wouldn't you? I mean, once you're put on notice, amending it doesn't seem to be, it seems to be the responsible one to do.
I suppose it could cut both ways, but the testimony from the Ohio Supreme Court was that they don't accept amended filings. That's not a thing that they recognize. So it looks more...
How would you correct it then?
They can't, it appears that they cannot be from the testimony from the Ohio Supreme Court. Now, that, again, that doesn't necessarily mean that all actions are criminal, but in this case, we have 3 years worth of omissions from 3 years worth of these different filings, these different failures. And when we look at, and this, I think this goes into the defendant's second assignment of error, which is the manifest weight here, that this is not one of those typical cases, maybe like the argument this court just heard previously, where you have testimony from 2 different parties and there's conflicting testimony and it goes down to a matter of credibility. The true evidence in this case are the financial disclosure forms themselves. So this is record-based evidence. It's pretty difficult to say that a conviction based on financial disclosure forms is not based on the manifest, or is not sufficient under the manifest weight of the evidence. And turning briefly to the defendant's third assignment of error, where he discusses allied offenses, we would agree that each of those 2 counts relate to one financial disclosure form. So we have a tampering with records count and a falsification count for each of the 3 different financial disclosure forms that he failed to adequately report on. But we would argue, which is what was done with the trial court, that those were done with separate animus so that each one of those should stand. Namely, the tampering with records, we believe, was complete when the defendant signed, I believe, the form at the end. And the falsification is knowingly making a false statement. So the falsification was the omission itself, and then the tampering is when the judge signed and affirmed at the end of the financial disclosure form that the information in there is complete. And quickly, I'm not sure how much time I have left, but I'd like to turn to the state's cross appeal. And we, in the tampering with records counts, the defendant was initially convicted of felonies. And he was convicted of felonies because the forms that were falsified were government records. And that's what was spelled out in the indictment. That was the evidence that was presented to the jury.
Counsel, am I correct that that special finding was not on the verdict form?
Absolutely, Your Honor.
And let me ask you another question. Talk about jury instructions. Was there any special instruction that you must find in this city, in this state, Ohio, that the jury also have to find per the instructions that they were government records?
That's a good question, Your Honor. I don't remember if the judge said that you have to find. I believe the jury instruction referenced financial disclosure forms, if I remember correctly, but I wouldn't want to misstate the record, and I'm not sure.
I think the court found that the degree of the offense was not on the instruction nor the enhancing element, that it was a government record. Would you agree with that?
Absolutely, if that's what the record says, absolutely, Your Honor. We would, I would agree. State versus Pelfrey, I think, is factually and legally on point here. So the argument that we're making in our cross appeal is really one that we're preserving for review because we understand that this court is bound by State versus Pelfrey.
Let me ask you a question about that though, because you filed a cross appeal, but they got an extension of time to find their initial appeal.
Correct, Your Honor.
So I guess my question is your cross appeal out of time?
I don't believe so, Your Honor, because we appealed it as a matter of right, because
Within the time frame?
I believe so, and I know that was briefed back and forth with this court, Your Honor, but we believed based on the filing deadlines, because generally under the appellate rules, the day of filing does not count, so it's the next day that triggers it, and we believe that based under those timelines that we did properly file our cross appeal. And I know that, like I said, we did file it as an appeal of right rather than as a, some other form of appeal, but.
We had a trial here, we had a verdict, and it was rendered. How does your cross appeal stack up against a double jeopardy argument?
Well,
You want to retract, you want this reinstated as a felony when after a trial and a verdict on a misdemeanor.
right, well, I guess we feel that it's not a double jeopardy issue because the trial and the verdict were for the felonies, and then it was ultimately reduced to misdemeanors under State versus Pelfrey at the sentencing hearing, so we believe that it wouldn't implicate double jeopardy.
What was this conviction for? Misdemeanor offenses?
Once the trial court granted their motion for Pelfrey at the sentences, yes, he was convicted of misdemeanor versions of this offense.
Thank you.
And unless this court has any further questions, the state is prepared to rest. Thank you, Your Honors.
I think the point I'm trying to make is we've got an attorney and a judge who says, I want to be able to divest myself of interest in this LLC. So he goes out and he hires counsel to do it for him. That attorney testifies, Attorney Burge, Judge Burge came to see me, says, I don't want to own this. I prepared an assignment, it's right here. This, in my legal opinion, and this is the individual that did it, he's been an attorney for a number of years. He does this on a daily basis. He does this for a living. He's a partner in a law firm in Avon.
And when did this happen?
This happened at the time that Attorney Burge was becoming a judge. So it was 2006, 2007. And now we're trying to say, well, maybe because of some non-filing of this assignment, it wasn't effective. Well, I think what happens is, and this court has recognized in State versus Morris in 2010, that criminal liability is based upon the state of mind of the appellant, not on the understanding of the other party. So if the prosecutor's office says, hey, I don't think this assignment is effective, does that mean that it's a false statement when he says, I don't own Whiteacre North LLC, even though his attorney who prepared the assignment says, this is what I told him, this is what I gave him? And I think that the issue is not whether as a matter of law this assignment was effective, or not as a matter of law whether he was a creditor or a guarantor. It's whether he could know as a fact that that's true or false. And I submit that's impossible. And I think that that is what Judge Crawford recognized. He still let the case go to the jury, I think erroneously, because he says 5 attorneys can say one thing and 5 attorneys can say another. So this court, I had an oral argument in this court a couple of months ago on 2 different cocaine cases, the same day, back-to-back oral arguments. And this court granted or denied my appeal on one fella. The very second appeal I had, post-Gonzalez, the court's opinion was totally different. Now, in which of those opinions did this court make false statements? None of them, because these are legal opinions. These are things that are subjective, that you pay attorneys a bunch of money to come in and construe your way. The last thing is, in terms of the tampering with records, that's got to have a purpose to defraud. I'm going to benefit somebody or a detriment to somebody else. Throughout this entire case, all the appeal process, there is 0 benefit to Attorney Burge. There is 0 detriment to another. The best that the Attorney General can come up with is that, in closing argument, said, well, if he disclosed these things, he couldn't be a judge anymore. That's completely false, unsupported by the record. They've never identified this. So if the jury thought maybe he should have reported it, yeah, there's differing opinions as to the legal ramifications of these answers, but I don't think that any of them should have ever been in a conviction. And if you cannot ever amend it, that means you can never make a mistake. So anybody who has ever attempted to amend their financial disclosure forms, and I'm sure James Burge wasn't the only one, I wonder why they weren't indicted, because I'm sure he's not the only person that's ever done it.
Yeah.
Thank you.
Thank you for your presentations today. The court will take the matter under advisement, issue a written decision which will be mailed to both sides, as well as posted to our website and matters.